Okay, we are live, and this is all about divorce and family law. We have attorney and certified family law legal specialist Tamara Benefield, and I'm attorney Vince Davis. Tamara, how are you this morning?
Outstanding. Doing great. How are you,
Very,
Vince?
I'm doing good, doing good. Hey, today
How's the weather up there?
the weather is it's sunny and it's 32 degrees. So I don't, not used to that, when I'm in California, but I'm
Right.
on I'm on the East Coast today. So today, I think we're going to talk about custody and visitation. How about that?
Sounds good to me. Let's do it.
Okay. So here is the situation. Mom and dad are in a have been in a custody battle. And actually the issue of physical custody has been decided, okay? And it's basically a 45 split to mom and 55 to father. All right. So the physical custody has been decided. The issue is whether they're going to have joint legal custody. And it's kind of an oddball situation, especially when it's 55-45. You just assume, oh, it's going to be joint legal custody, right? Well, in this particular case, the case started off with allegations that were eventually sustained against the mom that she was coaching the child. Okay. So those were sustained against her, and for many, many months and weeks, she had monitored visitation, supervised visitation, and over time, she got back in the game. All right. And now we are at the end of the case, and we want to have joint legal. I represent mom, another attorney represents dad. The other attorney keeps beating that drum about what the mom initially did, and I keep saying to the judge, okay, be that as it may, um, you sustain that allegation. We are here today, and mom now has 45%, and she gets overnights. She gets significant time with the child alone. So if you're really concerned about that, she shouldn't have 45% custody, physical custody,
Exactly.
but she does.
Exactly. Right.
I think there is something in the agenda of the father and his attorney. The father and his attorney, I think, want to do a move away sometime in the future. The attorney let that slip several months ago, and I think that they believe, either correctly or incorrectly, that this will give them an advantage in a subsequent move away.
Right.
So now let's assume that you are going to give counsel and recommendations to the mother as her attorney. There's one
Mhm.
additional a little fact that I left out, and it probably is very important. There are more recent allegations that the mom may be trying to influence or coach the child again. Hasn't been proven, hasn't been sustained, but there are those allegations. And my point is, well, why are you agreeing to 45% physical custody,
Right.
right? When and you have 55%. And right now, the two parents basically live in the same community here in
Oh,
California, in Southern California. Okay,
so what's the distance between them?
probably about 10 minutes, 15
Okay.
minutes drive time. So they're
And
really
when and when you say
almost.
the allegations were sustained, Vince, do you mean that there was a
Mhm.
domestic violence restraining order issued against her?
No, there was no domestic violence restraining order issued against her. There were some restraining orders issued against her, but they weren't DVROs. And but she's worked herself back in through counseling, through parenting, through conjoint counseling. So she's made a strong comeback on the case. So
Mhm.
now we're facing a contested hearing just on the issue of joint legal custody. When's the last time you had that kind of trial? right?
I
Just
I
don't even get
haven't.
up.
Yeah,
Right.
I haven't. I'm
Who does?
well, but I can see why you would have a whole trial on just that. Um, Joint legal custody is really the cornerstone of being a parent. It is the ability to decide health, medical, educational, let's say surgeries come up, weighing in on major decisions that affect the child's life, weighing in on extracurriculars on a day to day, which school they go to, the child goes to, which dentist they see, which procedures they get, etc. So I can see why a parent would take it very seriously that they should have joint legal custody. In fact, I tell my clients all the time, without joint legal custody, you're really deprived of being a parent. So, so it's worth fighting for. Absolutely. In your case, it's interesting because, like you said, even with the coaching allegations, she's been able to work up to 45%. Well, first off, if they live 10 minutes away from each other, I think strategically, for purposes of trial, um, you should push for 50%, meaning it may not move the needle with the child, but for purposes of triggering what are called um, the presumption, it's a presumption of a move away, right? It's a presumption that the move away is good faith and legitimate. And that happens when one parent has the lion's share of custody. So even though it's 5%, it triggers that presumption that a move away is in fact legitimate. And so I would try to disabuse the father of the notion that he's the lead parent or he's going to be making the decisions by saying, no, we're going to go to trial on the proper schedule and the timeshare, and it should be 50-50. I don't think a court is going to look favorably on parents who share 50-50 custody and think that one parent should automatically decide. I mean, after all, how long ago was the coaching issue? You said that there's some recent issues. So I mean, that's the biggest problem you're going to have is if there's any, evidence to that effect. But how long ago was the allegation sustained? What did she do to rehabilitate herself? And how does that old kind of antiquated issue in the case bear on her current decision-making ability? So right now, have they been able to decide simple things like doctor's visits? And I would try to build a constructive case. Like right now, there's no issue regarding their decision-making paradigm. They're able to come to meaningful decisions. They're clear on what the school is. They're clear on what the medical doctor, the dentist. They're clear on the extracurriculars. And I would alert the court that this is trial strategy to take the child away from the mother.
Here is another piece of information that I think I'm going to ask you about. Now, there is this allegation that has come up about recent coaching. Okay, hasn't been sustained, hasn't been proven. Mother denies it. Father says, no, it's true. If the mother goes to trial, there is a small chance that the judge could rearrange the physical part of the visitation. In other words, take her from 45 down to 30, or maybe even less.
Mm-hmm.
And what do you think about the notion, hey, you got 45% physical, go ahead and give him the sole legal, because you don't want to lose any of your physical visitation. And that's something to consider. Before you answer that question, I want to tell you something that happened recently. Okay.
Mm-hmm.
A client came back from almost 0% visitation to having about 48% visitation. When the case started, she had custody of the child, and the guy had like every other weekend visit. Okay. There were allegations made against her. They were sustained, but she was able to come back. She was listening to my advice very carefully. All right. Because she went from having custody to almost having nothing. We brought her all the way back. And then, you know how sometimes when you do such a good job, the client decides on their own, hey, I don't want 50-50. I want 80-20, right? Davis, you did such a good job that I know you can now pull off the miracle and put me back to where I was before. I advise against that, okay? I said, hey, let's just get out of this with 50-50, physical, legal. Client decides not to like my strategy. Client decides to get a new attorney. Client goes into trial with this sense of unbelievable confidence about what she's, has done. To make a long story short, end of trial with new attorney, not a very experienced trial attorney, ends up with 1 weekend a month.
No way. Wow. Well,
so, you feel good about your case, and then you jump off knowing that, Davis or your new attorney is going to, pull off the magic trick. So what do we tell the client in this case? Hey, I know you want that joint legal. Hey, we know the sneaky guy might be moving away in the future, but I don't, because this allegation has come up now that you're coaching again. How do you consider that?
Well, I think of it in a couple of ways. I mean, with the client that started off with primary physical custody and ultimately ended up having 1 weekend a month, I mean, this is why it's a very fact-intensive inquiry. I mean, typically, I think, at least for LA County, judges are now, it's not a bright line rule, right? 50-50. But it is the going rate, right? I think it is the going rate, meaning if you can achieve rough equality, because that kind of meshes with the idea that the child needs both parents, and usually if both parents are competent, then, an equal timeshare does benefit the child because they have both parents intimately involved in the child's life. So in the case where the parent lost and got to 1 weekend, I'm confident that there were some factual issues that came up during the trial that were devastating, that probably surprised the client. A lot of people don't realize this. For purposes of impeachment, your opponent does not need to let the judge or what's coming for trial. So impeachment evidence is the kind of evidence that surprises and takes away the credibility of the client. And once you do that, you're in the realm of, now can we take away time because this person is lying to the judge, not cooperating with the co-parent, and may pose a substantial risk of harm to the child. So that can happen. On the other hand, in your case where you have a client who worked up to 45%, right? And that's the posture going into trial. I think that the court is going to be looking at whether or not those allegations of coaching are substantiated. So where's that information coming from, and how do we know this is true? It can't come from the other parent. The other parent can raise the issue, but it's a problem of proof, right? because the other parent wasn't there, clearly, because they're not together. So is there minors counsel who can weigh on this?
There is, and minors
Mhm.
counsel is not on my team.
Meaning, do they think that there is coaching?
Well, they don't know. However, because findings were previously made, right?
Hmm.
They might be leaning that way, you know,
Yeah.
and it's a game time decision for minors counsel. Like after the minors counsel hears the evidence, then what? But I hate to have attorneys, especially minors counsel, leaning the wrong way when we start the case, because that means they continue to lean that way. You know, in the case that I told you that went awry for the client, there was a finding initially at an early hearing that the client was not credible by the judge. Okay. And one of the reasons why, one of the many reasons why I want to just, let's get out of here with 50-50.
Right.
I am told at the end of the client's trial, there was another finding that client wasn't credible.
Right.
So whenever you have that finding of not credible, you go into the big trial. That not credible finding doesn't disappear.
Right.
And in my mind, that's something that you always have to consider. So in the current case, there was that finding early on,
Hmm.
right?
Hmm.
And now we're facing just a trial on joint legal, like something that's very rare. And the judge is going to remember what he found beforehand.
Hmm.
So,
So again, just how it's fact intensive, I think that building a constructive case for your client. So of course, highlighting all the rehabilitative things that the client has done, but also just the basic premise that's embedded in the law, right? Is that children benefit from two people coming to a decision about what's best for them, right? And you can even tip off the judge to say, look, dad thinks it's best to move away with the child. And we know that that's usually not in the child's best interest to have one parent marginalized. We do that only in the event of that we have to protect the child. So what's the constructive case about mom? So in your case right now, what are the things that show the judge that she's a positive decision maker, right?
oh, yeah, there's a long list of things, long list.
So,
The, the
mhm,
problem is the new allegation
mhm,
by the father, because
mhm,
he saw this coming,
mhm.
he's a smart guy. What can he do to derail the train?
Well, you know what? That's the obvious vulnerability. But I would deal with it as a motion in limine to say, look, this is so prejudicial to, to her case, and it is so lacking in any evidence, right? After all, if this were true, why didn't he file a TRO? Why didn't he file an RFO for modification? Why didn't he ask for a psychologist? For the child to be in therapy so that the child, could be not just uncoached, but, to disclose to a neutral third party what mom is saying and doing to get the child involved in the case. I mean, it really just sounds like a thinly veiled strategy because they know that that's the sore spot rather than something that's truly substantiated before the court. And if that is true, then I would say, hey, if the judge shows any inkling of leaning against her, I would say, judge, then we need to continue this trial because those are new facts, new allegations. I need to do discovery. And maybe what we should do is get a psychologist, a forensic psychologist on this case, to examine the child to make a determination as to whether or not this true, it's true, and maybe give some advice to the court. So I'm thinking a 730 evaluator, perhaps. Even a child custody evaluation would pick that up. A PPA2 or something, might pick up after they interview the child. as to whether or not the child is showing evidence of being coached. I mean, it's a serious allegation. It means that one parent is, being dismissive about the child's well-being and basically trying to hack their brain on what to say and how to think about the other parent, which is a substantial risk to the child's well-being. So I wouldn't ignore that. And especially if there's some predisposition to lean that way, I would try to gather more information, and I wouldn't go into trial, getting ambushed by the other side on this allegation without any evidence. I mean, is there a recording? Is there a teacher? Is there a school psychologist saying this is what the child's saying? Is there a teacher saying this? Because
No.
if it's just dad, then I would turn this on its head. My approach for purposes of trial would be, I think it's Family Code 3027.1. But anyway, there's a specific provision that says that a false allegation of abuse is grounds to change custody. Meaning, if it turns out there's not a scintilla of evidence to this, right? And you can convince the judge that this was false and merely strategic to marginalize the mom, then I would do the reverse of your first case, meaning I would push for primary physical custody and sole legal custody. And that would be a trial strategy, so that, if the court doesn't know what to do at trial, they end up at 50-50 anyway. They end up at joint legal custody anyway. But if it's a false allegation, I would have conduct a mini trial on the complete absence of evidence for that particular allegation. And I would try to do a motion in limine to prevent the opposition from mentioning, an old sustained allegation, because we don't use character or habit evidence in family law. We don't. There's a tendency to, but there's rules of evidence against that. And it's a 352 issue. It's like she did her time. She made the corrective measures necessary. She's at 45%. So clearly, that's all trial strategy. So.
That's a brilliant strategy, Ms. Benefield. The motion in limine. I love that.
I mean, who does those anymore, right?
In family law, right?
Yeah, I actually have a nice sample if you want me to shoot it to you on character evidence.
Please do. Please.
I will. Are we having fun yet?
I'm sorry?
Are we having fun yet?
We'd love to have fun. You and I met at a family lawyer's trial boot camp. And you did something that I wanted to do but haven't done yet. I don't know if he still offers it. You took the Roger Dodd separate course on cross-examination. And I never told you this before, but when I talk to you, I can tell that you have become an expert cross-examiner. I hear the things that you say and I think about it and go, wow, you're hanging out with Dodd. That's something Dodd would say.
Right.
Do you know if he still offers that?
I do. And as a matter of fact, he offers them so often. I get emails, and what he does is he places them in destinations where you're like, I want to go to Maui, or so actually, so if you sign up, I'll go again. I loved that. I mean, that experience was so transformative for me as an attorney.
If you could forward me one of those recent emails, I'd love to see it. I don't know if I ever told you this. One of the reasons why I didn't take it, but I should have, is because I took, he used to have a partner, I forget the guy's name, but they did a video course on cross-examination.
Kolodny?
No, it wasn't Kolodny.
Okay.
Dodd had a video course, and he wrote a book with a partner, and I can't remember the guy's name.
I have it.
Very famous trial attorney.
Yes.
And but now Roger has taken this to a whole nother level.
Yes.
Right. So I thought, oh, the video course is fine. I've taken that. I'm good. But I didn't take his individual course on cross-examination, which you have, and you're a great examiner. You know, I want to tell you this because I've
Thank you,
seen
Vince.
this actually happen. You know, when you practice family law, a lot of people know the law, a lot of attorneys, and clients think that that's the most important thing. And in my mind and in my experiences, it's not. Everybody knows the law. And by the way, most, I won't say most, but a lot of judges don't want to hear the law from you. They already believe they know it. So
Right.
don't tell me the law.
Right.
Several years ago, this is maybe 5, 6, 7 years ago, I had one of my associates was doing a family law trial against a guy in the county of Los Angeles who was known as a very good family law lawyer. That's been his reputation for years, And I stopped by to see the trial. And I watched the trial and I realized something. You know, the guy that was really well known as a family law lawyer, he was a terrible trial lawyer. I mean, I actually felt bad for him and his client.
Yeah.
He was a terrible trial lawyer. My lawyer, who didn't have as much family law experience, but had more trial training, we won the case. And it was only because my lawyer was a better trial lawyer.
Right.
And I think people, when they make a decision on a family law case, they should be considering, does that attorney have the requisite trial experience?
Right.
Because trial is all about getting in and keeping out evidence, right?
That's
Direct
right.
examination, cross-examination, challenging witnesses. And people just think, well, you've done this 20 years, you know the law, that's all you need. That is not all you need. And in a close case, you're going to lose at a hearing or at a trial if your attorney isn't an expert trial lawyer like Ms. Benefit.
Well, thank you, Vince. I mean, I think you're right. And it's it's a physical experience when you're in court and you can just feel like clients may not know all the legal maneuvering and understand all of it, but you can feel when either the other side has lost the case or you're losing the case. You start seeing the judge's facial cues and you know it's not going your way. And a lot of times it's because attorneys haven't prepared for the question and answer part of it. And the reason why we do that is because we've decided, as you know, in terms of our cultural values, that the best way to arrive at the truth is through confrontation, is through the adversarial nature of argumentation. And when an attorney doesn't understand that, right, they're too much, there's attorneys who, mediation oriented, or they do collaborative law, or they like to write a lot and run up the bill. You should avoid that if you are going to trial. If you are going to trial, you need a trial attorney. Okay. And hopefully the case has been properly prepared, but it is something awesome on the flip side when you see how to destroy a witness's credibility on the stand. When you're so prepared and you know your facts, as the client knows them, because you've spent hours, and it takes a lot of time to sit down with your client and get all this information out of them. It
Right.
really does. But once you do, you go in there like with a sword and you slice through the fat and you get to these kernels of truth, and they matter for purposes of the legal determination.
Very good. Okay, Ms. Benefield, we're coming to the end of our show this morning. I know you have some things to do, and so do I.
All right.
Next week, you want to talk about some financial stuff?
That sounds good. Let's
Okay.
do it. Let's do it. Let's talk about attorney fees, why they're so important, and how they affect the outcome of the case.
That's a great topic and one near and dear to my heart. All right. You have a good rest of the week, and I'll see you next next Sunday.
All right. Goodbye, everybody. Thanks for watching.
Bye bye.